Hi everyone, class of TCOM 384. I'm going over the first section of Chapter 6, which is privacy, as well as to do with commercial appropriation. Some of the objectives that we're going to learn in this first step of the chapter are where did the Supreme Court and how they found constitutional rights to privacy, how the terms of privacy protect a person's physical being, personal space, information, and emotional security, how your reasonable expectation of privacy is used to protect spaces, and four types of privacy um, that are identified in court. What elements of privacy protect one's identity from commercial gain, how privacy is used to protect reputation, and what defamation when it claims fail, and how concepts of trespass, seclusion, secrecy, and access affect privacy rights in communication. So I'm going to get into all of my notes that I have here for you guys. Um, so one thing that the Supreme Court does with a constitutional right to privacy is they do not explicitly include the right to privacy. And one of the main examples of that is in Griswold versus Connecticut, that was found that the Constitution guarantees a right to privacy against governmental intrusion via pronumbus. I believe that's how you pronounce it. Um, but let's get into our first section of the chapter, which is the cell phone privacy or piracy, which is something that is oddly enough sounds about right, but sounds the same. But I will get into that. Um, so when it comes to privacy or piracy, the main thing that has to go with is the case of Barnicki versus Vopper. It was actually a radio station broadcast that taped a conversation, and Barnicki sued the private phone conversation that had been pirated. This broadcast cell phone exchange was a violation of ECPA, which is the Electronic Communication Privacy Act. Um, and Barnicki ended up winning the case, and it revived the scope of privacy in the sort of lawsuits that wouldn't recover over the damages of the First Amendment. And when you go to define the right of privacy, um, something that you need to know that a right to be left alone can mean protection from a few things, and that's unwanted intrusion by photography or public disclosure of details. Privacy includes the broad categories of rights that flow from the right to personally anonymous and to be left alone. And then lastly, it's although the U.S. Constitution doesn't explicitly contain a right to privacy, the courts have recognized the prenumbra of the right. Okay, so and when it comes to the right of it, there one stance of it is the constitutional privacy, and the prenumbra. I believe again, I don't know the exact saying of the word, so I'm just as close as I can. Is an aura or light shining through a filter as like a sunset is a partial shadow like above the horizon is what it says. And although the Constitution doesn't explicitly contain the right to privacy, the court recognized the penumbra of the right of the first, third, fourth, fifth, and then ninth and 10th amendments. And so another part of dealing the right to privacy are state laws and how they vary. And there's 10 states that guarantee the right to privacy, and that is Alaska, California, Florida, Hawaii, Illinois, Montana, South Carolina, Texas, and Washington. In this right to privacy, it is recognized by most states in statute, case history, or constitutional mandate, although the legal prohibitions are from state to state. So again, dealing with the right to privacy is the original scholarship of privacy, and that was founded by Samuel Warren and Louis Brandeis, and it was based on their argument for a legal protection of privacy and what they saw, what they need to protect a personal dignity, I guess, is what it says. Um, and as privacy is defined, it's up of four torts of privacy. It is the right to be personally self-sufficient and independent without constraint, and to the be uh, and the right to be left alone. Um, is another definition that is with it. And then the four torts of privacy are the intrusion upon personal solitude, the disclosure of embarrassing private facts, the appropriation of one's name or image for commercial gain, and then the shining false light on someone's public identity. And so when we get into the first tort of privacy, you fall into intrusion. And then intrusion is the privacy tort that protects people from their intrusion to private space from their private data. And since it protects the highest rights of intrusion, publication is not required for this tort. But when an offense occurs to the point and its information or visual is verbal, it's collected and it's not necessarily published. So it requires no further broadcast or publication in order to recover for damages, and is defined as an intentional personal invasion of one's seclusion or solitude. And then when it comes to intrusion, there's visual intrusions, and there's trespass, and fraud. Trespass is a common law tort that protects people from against interference with person, land, or possessions. Often the same set of facts that is the basis of an intrusion claims that it's also the basis of like trespassing. And then when it comes to fraud, fraud is an intentional material of misrepresentation of the fact that the defendant of the plaintiff relies on his or her detriment. So when it comes to superstition or intrusion, it says is superstitious recording an intrusion, and it is not an intrusion to make a recording of a person's voice, image, or other communication where there is no reasonable expectation of privacy. And when it comes to intrusion versus public versus private property, the right to privacy allows when individuals file claims for examples that I have right here are privacy and paparazzi, data snooping, intrusive images that are used without consent and their reasonable expectation of privacy. And then a cause of action for privacy invasion exists in public places, and the intrusion is to be found if it's highly offensive or unreasonable. And then the last statement I have on it for public versus property is the right to an individual is to be free from the intrusion of governmental surveillance, and it can be constructed from the Fourth Amendment of freedom that protects Americans from unreasonable search or seizure. And when it comes to intrusion with digital privacy, again, I brought up the ECPA, which is the Electronic Communication Privacy Act. Um, One thing that a federal law enacted in 1986 was that the ECPA established some privacy lifeguards against forms of online communication. So obviously, when it was coming out in the early 1980s with the internet, there was obviously laws and rules that had to be regulated along the time that everything was starting and moving to starting to move forward in technology. So when it comes to that, it was something that was just kind of just thought of on the run, and just more information and more rules came as time went by. Um, and then it wasn't until 1998 that the Children's Online Privacy Protection Act of 1998 gave the Federal Trade Commission power to prevent websites from indiscriminately collecting data from children under the age of 13 without parental consent. And then when it comes to that, it falls into what they call commercial appropriation. And the definition for that is the privacy tort that protects people from having likeness and commercial gain without his or her consent. So, one of the biggest examples of that was in 1902 with Robertson versus Rochester Folding Box Company. It set the precedent because they used the face of a teenage girl as a part of their advertising without the girl's consent, and the mother sued. But the Robinson family lost the case, and it made an effect where New York wanted to make a law for protecting individuals from their use of pictures and testimonials for advertising purposes. And commercial appropriation protects a person's name, image, likeness, or voice for advertising purposes without their permission. When it comes to commercial appropriation, the right to public publicity protects famous people, and it protects their people that want to impersonate them or make money off of them, which I can understand because nobody would want to be put in that position whether you're famous or not. Um, so when it comes to like impersonators, the likeness, voice, and image of them exploiting it is just to be gained from commercial gain, but obviously to get money off of them, which is something that should not be done in the first place. And the Comedy 3 test was something that was a measuring test to see if transformative elements were involved to warrant against the First Amendment. And the works were simply substitute for conventional depictions of celebrities or more celebrities as a whole. And the right was upheld. And it says here if the court sees more artistic creativity for commercial purpose, the victory goes to the artist and not the celebrity because it doesn't claim who his or her likeness was, to be completely honest. And then when it comes to celebrity in general, um, some things that we can see in the media quite often is when a celebrity dies, their privacy is something that is not really upheld by anything. I think a good example of that would be when Kobe Bryant died a couple of years or year ago, and people weren't really giving the right information to his death or what was happening, and it spread, and a lot of people lost their jobs in the media for misinformation, and that was something that was really hard for their family to deal with. So I think that's always a really good information or example to bring up when it comes to something that happens privacy after death. Um, but about that is certain rights expire for a person, when they die, and a dead person doesn't really maintain. Obviously, they don't have a reputation anymore. So, in spite of the impacts that they might have done on their hearers, the right that celebrities have can be recognized by some sorts, actually. Um, and the right that it publicly protects famous people who protect their image and likeness. And obviously, so a person like Kobe Bryant is something that he's highly respected and stuff. But that's up to obviously it was his wife that granted and publicly stated what he wanted to say and everything, and I thought she did a great job at it, to be completely honest. um, but when it comes to that, there's two things, and that's public disclosure and private facts. And when a person has taken offense to what has been published about them, they can hold a reporter liable for two things: the truthful acts that are conveyed with the plaintiff and that are highly offensive, and then there were no if there were no like concerns or legitimate like things that were stated or like shown in the public, I guess. Um, but as far as that goes, it goes a long line with privacy and how technology has helped shape to what it is today, and how we can learn to um, I guess, learn the odds and ends of what it is to maintain privacy within media and technology. Obviously, technology is changing rapidly from time to time, so there's obviously going to be changes in laws and regulations with that. But I feel like, in my opinion, I feel like we should just, be understanding and have a clear conscience of what it is that we need to be aware of when it comes to um, in the facts of law, when it comes to privacy, when it comes to anything on a phone or something that has to deal with someone, um, just their privacy in general. But that's all I have for today. Thank you, and talk to you guys soon.